Okay, Tom, do you want to try and get started here? About 6:10?
Okay, it's about 10 past 6. So good evening, everyone. I see that we have a quorum of the select board here. So we'll want to call the meeting to order, whoever's going to act as the chair, as I don't see that Sean's here at this point. And then I understand also that there's a quorum of the Human Rights Commission here this evening as well. So we probably want to do the same thing to open that meeting and then adjourn. So I think.
All right, this is Bill Olson. I will.
Select board is going to serve as the chair this evening.
That'll be Bill Olson, I think, if Sean's not on. So yeah, I'll call the selectmen meeting to order for the night of March 29th at 6 p.m. I'll do roll call. I'm in the car, so I can't see who's here. So Tom, you can help me on who else is here. So Will Olson here.
Sure. Rosie Kennedy.
Rosie Kennedy here.
And Jamie
Knudsen here.
Okay.
Tom,
great.
Tom, the Human Rights Commission hasn't organized yet, so they don't have a chairperson. So if it's all right with you, as I will do Wednesday night when we have our first meeting, I'll call the Human Rights Commission to order for Monday, March 29th at 6 p.m. and ask the members to signify that they're here by saying their name.
Nancy Steffes is here.
Ann Brady is here.
Maya Beach is here.
Elena Walsh is here.
Christina Holtz is here.
Jared Hughes here.
And Jamie Knudsen here. What a good showing from the.
Yeah, that's great. Thank you for all for coming. So Joe, did you want to say anything to get us kicked off here before you take off, or do you want me to just jump right into it?
Well, just thank everybody for coming and welcome them all. This is the first. We'll probably do this annually. This is an opportunity to just remind folks, to give people a refresher on open meeting law and state ethics. And KP Law is our town council, and they offer this to us on an occasional basis to be able to just help us stay on the right side of things. So with that, I would turn us over to the capable hands of our attorney, Tom McEnany. Thanks.
Okay, thanks, Joe. So as Joe indicated, I'm Tom McEnany. I'm a shareholder with the firm of KP Law. We serve as town council for the town of Hamilton, and we've served in this capacity for a couple of years now. So tonight we're going to talk about the open meeting law, which is a very exciting and timely topic that I'm sure everybody is just dying to learn more about. So the seminar, it's designed to really be an overview of the various issues that arise for members of public bodies that are subject to the open meeting law. And to just give you some guidance, it's not really designed to serve as, legal advice for any specific issues. Of course, if you have any questions, feel free to either, probably the best way to do it would be to use the raise hand function, which you can find at the bottom of your screen if you're on a laptop under the reactions button feature. And there's a raise, and any questions you have, I'll try to answer them as we go. And then obviously if after the meeting it adjourns, if you have any questions or if there are any particular issues that you want to discuss, feel free to give me a call and I'll give you my cell phone number so you can reach out directly. So with that, I put together a PowerPoint presentation, which I will share the screen on, and we'll go through it. So, okay, so all right, so tonight we're going to talk about the open meeting law, which is one of three of what would be referred to generally as sunshine laws. So sunshine laws are designed to shed light on the public process and decision-making that public boards, committees, and commissions go through when they're establishing various public policy and making decisions. The open meeting law is probably the most common one that you'll come across as a board member. The other two, conflict of interest is another one, obviously, that comes up that you'll need to be aware of, and the public records law, which doesn't so much concern board and committee members as really more town staff. But we will touch a little bit on the public records law at the end of this presentation. Okay, so the purpose, as I said, of these types of laws is to eliminate the secrecy surrounding deliberations and decisions upon which public policy is based. It's basically to ensure governmental transparency so that the public can see kind of how the sausage is made, so to speak. Under the open meeting law, public bodies can really only conduct public business through public meetings unless there's an exception that exists. The three major issues that arise with respect to the public, to the open meeting law are notice, purpose, and minutes. And so we'll address these in some detail. But the open meeting law can be found in General Laws, Chapter 30A, Sections 18 through 25. And the Attorney General's Office, which oversees and enforces the open meeting law, has promulgated regulations that are found at 940 CMR 29. The open meeting law underwent a fairly major rewrite back in 2009. So this, the current version of the law has been in effect since 2010, but these types of laws have been around for decades at this point. So I think one of the first things that we want to talk about before we get into what the definitions are, because that's really, what defines whether a public body is meeting, what's the appropriate topics for deliberation, what exactly is a public body, as that term is used in the open meeting law, and some of the other definitions that apply. I think the first thing that you need to know is that what the open meeting law requires is that meetings of a governmental body must take place in public, but that does not necessarily give the public the right to speak at a meeting. Ultimately, whether to allow public comment or unless it's a public hearing where a person is or an entity is entitled to present a case to a governmental body, whether it's a board or commission, usually acting in more of a quasi judicial capacity. Unless it's that type of a situation where you have a hearing, the public is not necessarily permitted to speak. The chair can certainly allow it to take place, and there are certain issues that you want to be wary of in light of First Amendment concerns, but that's, I think, a common misconception that people have, particularly people who are new to town government. And it's simply that your meetings have to take place in public. The public is entitled to observe, but not necessarily participate in the meeting. Okay, so what is a meeting? So a meeting is defined under the law as a deliberation among a quorum of a public body to discuss matters within the jurisdiction of the body. A meeting does not include town meeting, which is specifically not subject to the open meeting law, but it would include basically any other meetings that you would have usually on a weekly, bi-weekly, monthly basis. Deliberation includes an oral or written communication through any medium, including email, text messages, potentially social media, between and among a quorum of a public body on any public business within its jurisdiction. So what does that mean? That means that if a quorum of a public body, which would be a majority in most instances, is discussing either through oral or written communications, so that would be email or any, and it also would include serial communications, which we'll talk about a little bit further, about any public business within its jurisdiction. That would be anything that the board would vote on or make a recommendation on is subject to the open meeting law. So if a quorum of the board, for example, is talking about, the upcoming Red Sox opening day, that would not be something that the board would be making a recommendation or taking a vote on typically. So that would not be subject to the open meeting law. Quorum, as I said, is generally speaking would be a majority of the members of a board or commission. And a public body is basically any multiple member board, commission, committee, or subcommittee, however it's created, whether it's elected, appointed, or otherwise constituted, established to serve a public purpose. Does anybody have any questions so far? Okay. Are you able to see the raise hand function?
Yeah, I don't have any.
Okay, great. I wasn't sure if I was able to see that. Okay. So first definition is what is a meeting? And a meeting, as I said, includes basically any deliberation among a quorum of a public body for the purposes of discussing matters within the jurisdiction of that body. It does not specifically, by definition, include an on-site inspection or a attendance at a program or a social event, provided, again, that there's no deliberation. That's really the key. So if, say, for example, the Conservation Commission receives a request for an order of conditions, and the Conservation Commission wants to arrange for a site visit to go out and take a look at the property, you can do so, and you're not required to post for that site visit as long as the members do not deliberate during the course of that on-site inspection. If you think that you're going to deliberate, or you're going to want to discuss what you saw at that meeting, at that inspection, I should say, then you want to post notice for a follow-up meeting, typically at some point right after you think the meeting will end. So for example, if the site visit is for 6 o'clock at night or something like that, and you think it's going to take about an hour, you probably want to post a meeting for, say, 7:30. And at that time, the board members would be able to discuss and deliberate on what they observed during the course of that inspection. A meeting also does not include attendance or by a quorum of a board or committee at any public or private gathering or social event. So if an employee at town hall, for example, retired and there was a retirement party that was being held for that individual, then members of a board, a quorum of the board could certainly attend that. And as long as there's no deliberation on business that will be in front of the board or upon which the board would make a recommendation, that would not constitute a meeting. It's always best to avoid creating the appearance that that business is being discussed at a public meeting, but something like that would not be subject to the open meeting law. Deliberation. So again, going back to the definition, deliberation is an oral or written communication between or among a quorum of members of a public body on any public business within its jurisdiction. And so that includes specifically email communications, text messages, and serial conversations. So if there are 5 members of a board, for example, and A talks to B, B then talks to C, C then talks to A, A then talks to D, D then talks to C. You have a situation where there's quite possibly will be a finding that the open meeting law was violated, because even though there's not a quorum of the members in the discussion at any one time, you're not able to, the Attorney General's office will find that the open meeting law is violated if there are serial conversations that take place between board members, with one person, for example, is being used as like an intermediary. Same would go for using a town staff person to do that. So if the planning board decided if the chair of the planning board, for example, wanted to poll the members of the board to see how they're going to vote on a particular issue, you couldn't use the town planner, for example, for the purposes of doing that. It also, deliberation specifically excludes distribution of meeting agenda, scheduling or procedural information, or the distribution of documents and like a package that the board is going to consider at an upcoming meeting, so long as there's no deliberation or no expression of opinions, thoughts, or ideas about the document. So, for example, it's perfectly okay to use email to send out, if the chair sends an email out to the other members of a board or committee to say, geez, are you guys, is everybody available for a meeting next Tuesday night? That would not be considered deliberation. And the same would be true if the chair were to send out an email saying that at our meeting next Tuesday, we're going to talk about this permit application that we received, or this contract that was sent to the town for review. And that's fine as long as it kind of stays there. But if there's a comment to say there's no way I'll ever vote for that project, or I think this plan is terrible, or I think this is great, we should vote to approve it. Anything like that, where there's an expression of opinion or some sort of value judgment or other thoughts about a particular matter, which ultimately will be coming before the board in an open meeting, is prohibited, and that would constitute a violation of the open meeting law. So along in that same vein, always beware of the reply all button. Generally speaking, even if you email something to all members of the board where you have expressed an opinion, and even if nobody responds to that, it still has been found to be a violation of the open meeting law by the Attorney General's office. So you definitely want to be careful about the use of email with board members and limit it to really those things such as scheduling and just distribution of documents for the purposes of discussion at a further meeting. Social media. So social media is fairly well used and pervasive at this point in society. So I would expect most people have some form of Facebook, Twitter, Instagram, Snapface, I think as Bill Belichick calls it, and some of these other social media sites, I'm sure that people use for various purposes. Social media use can be the subject of an open meeting law violation if a member posts something on a social media site, whether it's a Facebook page or a group chat or blog, listserv, or something else that other members of the same public body could see. It could turn into an open meeting law violation if you direct a comment, for example, to a particular board member. If you post something and there's direct comments from other board members and they relate to something that is ultimately either going to be or could be in front of your board. that can be an issue. So you definitely want to be cautious and in terms of your use of social media when it comes to town business and business that will potentially be in front of your board or something that your board will be voting on or making a recommendation on. Some of you folks obviously are elected officials as well, so it's always best to if you can, to kind of separate your social media accounts for campaign and elections purposes if you're up for re-election, and because obviously you're going to want to comment and people are going to want to see what you have to say about various issues that are important and relevant in the town. But at the same time, you just need to be careful about about whether or not other board members are going to respond, or you're going to respond to other board members, which could very well result in an open meeting law violation, depending upon the nature of the communications. Best practices with respect to these issues. I think it's always best to assume that any email that you send out may very well end up being forwarded to unintended recipients or disclosed in the response to a public records request. So you want to make sure that the content is limited and is appropriately worded. I always refer to this as the front page of the newspaper test. So before you hit send on an email, you want to make sure that whatever you put in that email is something that you would not be completely embarrassed if it showed up on the front page of the paper. Generally speaking, you want to avoid, and this goes not just for open meeting law purposes, but really for public records purposes as well. So we respond to, my office responds to quite a few different public records requests on behalf of the cities and towns that we represent. And some of the things that you see people put in writing and emails will be somewhat eye-opening, to say the least. So, and in most cases, you can't redact information from there. So if it says that, this developer is a big fat jerk, or some words that are much more colorful than that, then it's usually something that's going to have to be produced in response to a public records request. So you just want to make sure that, particularly with the use of email, that you're cautious in terms of how you word things. If you're attending a meeting I talked a little bit about site visits already, but public bodies can attend meetings of other public bodies. And you often see meetings posted as joint meetings, for example, between like the select board and the finance committee, or between the select board and the Board of Health, most recently with respect to many of the issues that have come up during the course of the pandemic. And if you anticipate that a quorum of a body will be attending a meeting of another body, our recommendation is always to post a joint meeting under those circumstances. Other members of one public body can attend meetings of another public body. But if a quorum attends, then it just raises the potential risk for an open meeting law violation. You can speak as long as you're speaking as an individual, and it should be made clear that you're not representing the body and that you're there in your individual capacity. And as long as the members are speaking through the chair and not to or kind of with each other, shouldn't sit together. That obviously would raise some concerns potentially if someone were to file an open meeting law complaint. But always best to post a joint meeting if you think that you will have multiple members of your board attending a meeting of another board. Okay, a public body, again, by definition, is any multiple member board, committee, or commission, including subcommittees, however created, whether they're elected or appointed, for the purposes of discussing or advising on any public business. So a subcommittee is a multi-member body created to advise or make recommendations to a public body. Subcommittee can also be created by an individual for the purposes of advising that individual. So with respect to the open meeting law, only subcommittees that are created by a multiple member body are subject to the law. So in this case, if the select board, for example, created a subcommittee for the purposes of advising or making recommendations to the select board on a particular issue, they can do so, but that subcommittee would be subject to the requirements of the open meeting law, even if they don't necessarily have decision-making power and they're just constituted for the purposes of making recommendation or giving advice to the board. So some practical ways to avoid the application of the open meeting law would be if one person is assigned to look into an issue, for example, one person cannot constitute a subcommittee. So, for example, I worked recently with one member of a board of selectmen for the purposes of investigating and doing some research on potential options for host community agreements for a marijuana facility that was going to site in that particular community. So when you work with, when it's one member of the board that's been assigned to take on a particular task and then report back to the board on any findings, one person does not constitute a subcommittee, even if that person is working with with, for example, the town administrator, town manager, town council, town staff. That's generally okay, as long as the board does not specifically create a subcommittee that would constitute those particular individuals. So anytime there's two or more people are tasked to investigate an issue, for example, it most likely would create a subcommittee. So you just need to be careful about that issue. And as I said, it only applies to subcommittees created by a multiple member body. So if the subcommittee is created by a sole officer, for example, town manager puts together a subcommittee to look at potential candidates for a position that's open in town. He can certainly do so. And because the town manager is not a public body, it's an individual who has the authority to act independently, that subcommittee that's created by the town manager would not be subject to the open meeting law. Same goes true, for example, a superintendent puts together a committee for the purposes of vetting potential candidates for a principal job that's open. Same thing, and that's referred to as the Connolly rule, which is based upon the Connolly case. So, but if the subcommittee is created by a multiple member body, you can generally consider that the open meeting law will apply to that subcommittee. Okay, meeting notices. So at a bare minimum, the notice must include the date, time, and place of the meeting, as well as the topics that the chair reasonably anticipates discussing. If it's possible that you might discuss an issue, you generally want to include it on the agenda, and then you can either pass over it or just continue the discussion to another meeting. The topics must be sufficiently specific for a reasonable person to read the agenda and understand what will be discussed. So this is a topic of frequent open meeting law complaints that are filed with the Attorney General's office. And it's something we'll talk about a little bit further as we go through the program this evening. But suffice this to say that it is important to use as much specificity as you can in setting forth what the topics are that will be discussed by the committee. Recurring items such as, new business is not good enough. If you're going to for example, talk about renewing certain licenses, then just including an agenda item that says renewal of licenses is not good enough. You should identify the specific license types and the either by owner or property address, or business name, or some additional details so that people will know which licenses you are going to renew. With respect, as I said, with respect to the specificity of agenda, that's a topic of frequent open meeting law complaints that are filed with the Attorney General's office. This is one example from a decision from 2011 where local soil board had noticed a hearing where they were going to renew fall soil permits, and the board should have basically that the AG's office found that just renewal of fall soil permits was not sufficient in terms of an agenda notice, and therefore what should have been included was additional details concerning the specific permits, such as the name of the applicant and the location that's under consideration. With respect to notices, you also want to avoid, to the extent that you can, using acronyms or other abbreviations. Members of the general public might not be, familiar with some of the terms of art and the abbreviations that are used by various boards and committees. So if it says OOC for Conservation Commission, members of the Conservation Commission and people familiar with conservation issues might understand that to be an order of conditions, but someone in the general public might not have that same kind of specific detailed knowledge of some of the things like that would come before Conservation Commission, for example. When you are going to have an executive session, you also want to specifically identify that in the agenda and cite to the statutory section, as well as the purpose for which the executive session is being held. And you want to provide, again, as much detail as you can without negatively impacting the body. So, for example, if board or committee is going into executive session for the purposes of discussing litigation strategy under purpose 3, and we'll talk about some of the purposes a little bit further on, but you would want to include in the agenda item executive session with a citation to General Laws, Chapter 30A, Section 21A3, Purpose 3, to go into executive session for the purposes of discussing litigation strategy. And the chair declares that having discussion in open session would be detrimental to the town's litigating position. And you want to identify the case if it's a case where the town has been sued, which, since that would be kind of already a matter of public record. You want to avoid generally kind of shorthand references, as I had said, to, for example, if you're going into executive session for the purposes of contract negotiations with a union, you want to specify which union you're going into executive session to negotiate with. Or if it's for purposes of going into executive session and negotiate a contract with a non-union employee, you'll want to specifically identify the position in question. Okay, so as I said, so the meeting notice must be posted 48 hours in advance of the meeting, and that excludes Saturdays, Sundays, and legal holidays. So if the board is going to meet on a Monday, you would need to post it by Thursday, for example. And you also, in the posting, you need to include the agenda, which includes any matters that the chair reasonably anticipates will be discussed. If something is not at the time of the posting, the chair didn't have a reasonable basis to think that that would be the subject of discussion in a meeting, that doesn't mean you can't discuss it If it's something that you need to act on, our recommendation is to amend the agenda and post it as soon as possible to show what was changed. So typically we would say to add it if, it's in normal kind of black ink, for example, to post the updated agenda, so that it shows the new item in red or a different color, or it's in bold, or there's something else that would alert a member of the public that this is new and has been added since the agenda was originally posted more than 48 hours prior to the meeting. What the Attorney General's office has said is that if you didn't anticipate something and it came up, you certainly can discuss it, but it is recommended that you not take action on it at that meeting unless there would be some detriment to the town if you didn't. If something comes up and you absolutely have to act on it because there would be some detrimental impact, the town would lose some sort of a right or something else, then it's okay to vote on it. But otherwise, what the Attorney General's office recommends is that you post that matter for an upcoming meeting, have a discussion and vote on it at that time. Okay, locations of meetings. So will become an issue again. I assume at some point we probably won't be doing all of these via Zoom as we are now, but meetings must be in a location that is ADA compliant so that the public, all members of the public are able to access the meeting. So you may have seen that the state has gone to the next phase of the reopening plan. So at this point now, we are able to hold indoor meetings with a total capacity of 100 persons. Again, provided you can still socially distance and wear a mask, but the indoor capacity limitations have increased. So I suspect that as the more people get vaccinated and hopefully the case count continues to hopefully go down, although it seems to be spiking again a little bit, we'll be back to a situation where boards and committees and commissions will be able to meet in person. And that's when, issues like accessibility, are you meeting in a location? If you're going to go into executive session, we have the ability to shut the door and to exclude the public from that portion of the meeting. Things like that, those will come back into play. And those are some of the issues that have come up in the past. There's a reference to the decision from 2012 from the Attorney General's office where the school committee was held to have violated the open meeting law, where they held a meeting in the high school. The person who was at the front door greeting the public left, presumably to attend the meeting, and door was locked. The public wasn't able to get in, and that would be that AG found an open meeting law violation under those circumstances. Okay, so timing again, 48 hours prior to the meeting, unless there's an emergency. For an emergency, that means that it would have to be something that would have a detrimental impact on public health and safety. Poor planning is not an emergency. So that's something to keep in mind. If it's the Attorney General's office will find a violation under those circumstances. If, it turns out that the board, just forgot to include something, for example, or forgot to act on something. And if the board doesn't act by, tomorrow at noon, there's going to be some detrimental impact on the town, but it's something that you knew about for months in advance, then the Attorney General's office would likely find a violation if you were to just meet this evening, for example, to try to beat that deadline, where it's not really a true emergency. So it really has to be something that's related to like public health and safety. We've obviously, over the past year, have seen quite a few emergency meetings to deal with some of the issues related to and public health concerns related to the pandemic. But generally speaking, that's really the only time where you can determine that a true emergency exists. You might see it where there's a storm, for example, and there's storm damage, so you need to take action immediately to secure a building or something to that effect. Sure. Rosie, did you have a question?
Yeah, just a quick question. It was a slide back. Just in-person meetings, sometimes if there are a lot of people there, it can get really noisy. And so looking at the direction here, it says we cannot close and lock the door. But if things are really noisy, can we close the door until things quiet down outside? I know we've had controversy about that in the past, so just thought I'd ask.
So yeah, it depends if it's an open meeting of the board, for example, and yeah, as long as the door's not locked and it's clear that people would be able to access the meeting room. Yeah, I think that's fine to keep the noise down. I've seen, I've attended meetings like in the school, for example, where Board of Selectmen might meet in a school building that because that's where like in this instance, and I'm thinking of where the cable access television studio was kind of set up. So for purposes of broadcasting the meeting, they would usually meet in a meeting room at the high school in the evenings. But there were also, sometimes it would be basketball games or volleyball or other school activities that were going on. So there were often a lot of people in the school who weren't necessarily there for the selectmen's meeting. So we usually shut the door under those circumstances, and there would be a sign that said, selectmen's meeting in progress, but, feel free to come in. So that's okay, as long as it's clear that people would have the ability to still access the meeting.
Perfect. Thank you.
Sure. Okay, so, and this one's with respect to the agenda, again, it has to be posted 48 hours prior to the meeting, unless it's an emergency meeting. And that does not include Saturdays, Sundays, and legal holidays. The town clerk should date and timestamp the notice so that it's clear what day and what time of day it was posted. I just recently actually had an open meeting law complaint where the town clerk date stamped but did not timestamp the notice, and we had to acknowledge a violation under those circumstances, which, the penalty is not really severe, but it's just more of a slap on the wrist under those circumstances from the Attorney General's office. But it's best to avoid having to even deal with the open meeting law complaint by just ensuring compliance. Okay, so again, with respect to emergencies, natural disasters, public health issues, public safety issues, those all qualify. Poor planning does not. To the extent that you can, we always recommend that you comply with the open meeting law. So even if you're going to have a meeting that's less than 48 hours after you post, we still recommend that you post the meeting, even if it's within that 48-hour time period. You need to limit any discussion during an emergency meeting to the emergency matter. So, it can't be used as a reason to talk about other things. You still should take meeting minutes. And you also may want to consider posting a regular meeting as well to allow the board to vote to ratify and confirm any action that was taken at the emergency meeting. So towns typically post in multiple locations. There's usually the town bulletin board. Oh, I see a hand up for Jay Butler. Jay, go ahead.
Yeah, I have two questions about the 48-hour posting.
Yes.
Two scenarios. One, there was a missed handoff and the meeting did not get posted during the 48 hours, but the committee didn't notice that and they all appeared for the meeting. Can they go ahead with an informal meeting and not vote anything?
What I would recommend doing under those circumstances is not going forward. I mean, again, you're going to have to do it over again anyway, so it's best to probably not proceed. I mean, if you have a brief discussion, I don't think that there's any probably huge issue there, but certainly you can't vote on anything, and it's best just to say, if it's recognized at that time, to just just indicate that, okay, we found that there was an error here. We're going to repost for a different date and time, and just hold the meeting at that future date.
Similar question. The meeting gets posted properly within the 48-hour limit, and the members of the committee assemble, but they don't have a quorum.
Right.
And-
So, yeah, so you're not able to proceed. Sometimes what will happen is, again, there might be some brief discussion, but there's obviously the commission, the committee or public body has no ability to take any formal action under those circumstances. So typically we would just recommend that you, just indicate to the public or anybody who's there that that a quorum is not present, and therefore we're going to repost for a different date.
But you can still sit and have an informal discussion among the people there, but just not vote on anything.
You could, yeah, I think you could. The problem is that potentially what could happen is, and I can't say that I've seen this, but I could envision it happening, where you have a 5-member board, 2 members show up, they have a discussion about a particular issue, and then one of those members has a discussion with one or more of the other board members, and it's viewed as a serial communication that was outside of a properly posted open meeting, and you find yourself having to defend against a open meeting law violation. So I think it's best to, limit the discussion under those circumstances. Again, if there's less than a quorum, having a discussion about a matter that's within the jurisdiction of that board, that's okay. It's not subject to the open meeting law. However, it's when there are serial communications among board members that, raises the potential that an open meeting law violation would be found if somebody were to file a complaint.
Okay, thank you very much.
Sure. Okay, so with respect to the posting, again, that's handled by the town clerk. Typically, the clerk would post the agenda in the normal places where you post, which is typically on the public bulletin board that's available at all hours somewhere at or near town hall, and then also on the municipal website, which is generally designated as the alternate if presumably the town has obtained approval from or notified the Attorney General that that's the case, which pretty much everybody has at this point. And you need to make sure that it's posted in all locations within that 48-hour period. So you can't post just on the website and not at town hall, or just at town hall and not at the website within the 48-hour period, or else you'll be found in violation. Okay, so there are two. Sure.
I got a question in the chat.
Okay.
Is a vote required to adjourn a board or committee meeting, or is a meeting adjournment simply announced by the chair?
Board should vote to adjourn. Yes. Yep. So the chair will call a meeting to order, and the board will, generally, and certainly now that we're doing everything via Zoom, you're required, and we'll talk. I put together a few slides specifically related to kind of the COVID-19 regulations and holding virtual meetings that we'll get to towards the end. But boards will need to, particularly on the Zoom platform or any kind of virtual meeting platform, required to vote to, by roll call to open the meeting. Same is true with respect to adjournment, is that the board will need to vote to adjourn again, because it's in the virtual world, everything has to be by roll call vote. Okay, so there's basically two, I guess, more or less, kind of two types of meetings that boards and committees have. There's the open meeting, and then there's executive session. So executive session, if allows a board to meet outside of the public view with respect to certain issues. And General Laws, Chapter 38, Section 21 lists out what those various reasons are when you can go into executive session. And they include such things as purpose 1, to discuss reputation, character, physical condition, mental health, discipline, dismissal, complaints and charges against an employee. Purpose 2 is to conduct either strategy sessions to prepare for either contract negotiations with non-union personnel, or to prepare for collective bargaining, or to actually negotiate with that employee or with the union. Purpose 3 is to go into executive session for litigation if the chair declares that having a discussion in open session would have a detrimental impact on the public body's litigating position. Purpose 6 is to consider the purchase, exchange, lease, or value of real property if the chair declares again that the open meeting may have a detrimental effect. So we can let's talk about these a little bit. So purpose 1 is the so-called, that one involves what are referred to as individual rights. And so if you're going into executive session for the purposes of discussing either the reputation, character, physical or mental health of a person, discuss the potential discipline or dismissal of an employee, then you need to notify that individual in writing at least 48 hours in advance of the meeting, and the individual has a right to attend and participate in that executive session. He also has the right to have an attorney present, although the attorney is not necessarily permitted to participate unless the chair so allows, although in most cases the chair would. And the person can ask for that to be held in open session instead of executive session. So even though the board may prefer to go into executive session for the purposes of discussing what may be kind of sensitive issues, or potential disciplinary action that the board may take against an employee, the employee can request that that meeting be held in open session, and the board would have to abide by that request. So, which I've seen, actually, believe it or not. So that sometimes you would think that people wouldn't necessarily want some, what is often kind of dirty laundry aired in public, but sometimes people feel that in certain circumstances they would rather have that discussion in a public setting as opposed to in executive session. Purpose 2 is to either have strategy sessions internally, or you can actually go into executive session with the union representatives, or in their bargaining team, or with an individual to negotiate a contract. And that's one of the times when the other side is essentially permitted to be in the executive session with the board. Under purpose 3 and 6, for example, if you're going into executive session under purpose 3 to discuss litigation, the other side cannot be present during that discussion, because the purpose for entering executive session is to discuss litigation strategy. So it wouldn't really make a lot of sense if the other side was in there to listen to what you had to say. Similarly, with respect to purpose 6, if the town is thinking about purchasing a property or perhaps taking a property by eminent domain. And you're trying to decide, okay, well, how much do we think the property's worth, or how much do you think we should offer? That's obviously a discussion that the board's not going to want to have an open session, because if the person whose property you're looking to acquire knows how much the board is willing to pay, it would obviously have a detrimental impact on the town's bargaining position there. Also, and with respect to the agenda items that relate to these, typically for purpose one, wouldn't not necessarily identify the individual in question. So the agenda item might say, executive session. Board's going to enter into executive session under 30A, section 21A1, purpose 1, to discuss, reputation, character, physical condition, mental health, blah, 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 of a employee, of a public officer, employee, or staff member, and that's it. Because then if you identify the particular individual in question, then that obviously can be problematic from a privacy standpoint, because, particularly if you're going to go in to discuss something that could have a detrimental impact on somebody's reputation, or you could be in there to discuss somebody's physical health or mental health condition. Obviously, that's information that's highly confidential and private. So you wouldn't want to necessarily identify the individual who you're going in to talk about, because then, that would subject them to, the public would know who you were in there talking about, which would be kind of to some extent defeats part of the purpose of why you're going into executive session. Similarly, with respect to number 2, under those circumstances, typically there's no reason why you wouldn't identify either the union or the individual in question who you're going to be negotiating with. Ultimately, public employees' salary information and the public collective bargaining agreements, that's all public data that ultimately will be, in the public domain. So the fact that the board's going into executive session with, person X, again, I would identify by position as opposed to by the individual's name, is not, that's not something that would be viewed as detrimental to the town or otherwise compromise the purpose for which you're going into the executive session. Purpose 3, with respect to lawsuits, if it's a pending lawsuit that's already been filed, generally there's no reason why you would not identify that specific lawsuit. So it might say to go into executive session to discuss litigation strategy, and an open meeting may have a detrimental effect on the bargaining or litigating position of the public body, and the chair so declares. And then identify the case, Jones versus Town, for example, or whatever the name of the case is. That same thing may not be the case if the town is contemplating litigation against someone. If the town was going to file a lawsuit to, enforce COVID-19 regulations, for example, for somebody that's been business, maybe that's been in breach of the governor's orders, you under those circumstances, you probably would not want to identify the particular case in question, because that would be potentially detrimental, because the person could take some sort of defensive action before the litigation begins. So, it's going to be somewhat of a fact-specific determination, but generally speaking, I would say the more is better with respect to any kind of item under purpose 2, in most cases under 3, 6, again, probably, if the town's going to be acquiring property, it's most likely not something that you would want to identify the property address or the owner, because, then it kind of gives away the secret, so to speak. Okay, so this slide addresses some of those issues that I just talked about. So the process to convene an executive session. So this is something that, in my experience, most boards and committees probably get wrong more often than they get right. So even if the board is going to meet just solely for the purposes of having an executive session and there's nothing else that's on the agenda, the meeting agenda still has to be posted first as an open session. And then the agenda item would be to go into executive session and then ultimately adjourn. So I think that's something that boards and committees don't often get correct. In order to go into executive session, you first have to open in open session. Somebody would make a motion to go into executive session and you would state the purpose why you're going in. You can go into executive session for more than one reason. It happens frequently actually where Board of Selectmen may go into executive session on one night at the end of their meeting. They may have 2 or 3 different topics that they're going to talk about in executive session. So it might be to talk about potentially disciplining an employee, in which case that would be one purpose. It may also be that they're going into also talk about a pending lawsuit involving the town or to acquire property. But it's not uncommon to see a board go into executive session for multiple reasons. So if the board is going in for multiple reasons, then you want to read off, who's ever making the motion is going to want to read off all of the reasons why you're going into executive session. And then the board would then vote on that. For executive session, right now, everything, again, because we're in the virtual setting, is a roll call vote. But executive session is always a roll call vote, even if you're meeting in person. So to go into executive session, to come out of executive session, and any votes taken during the executive session are all taken via roll call. The chair would want to announce if the session will or will not convene in open session afterwards. So typically there'll be some announcement to say, we're going into executive session and we're not going to come out except for purposes of adjournment. And you'll only want to discuss matters that are cited in the notice. So if you're going into executive session to talk about Jones versus the town, you really need to limit the discussion to Jones versus the town. You can't talk about possibly acquiring 125 Main Street, for example, or talking about disciplining an employee. You need to kind of stick to the noticed agenda. Executive session, like open session, you also have to prepare meeting minutes, and the board should timely review and approve those minutes as they do with any other meeting. Executive session meeting minutes can be and should be reviewed in an executive session. So for example, if the board meets to go into executive session, and then at the next board meeting, you plan to approve the meeting minutes, including those executive session meeting minutes, you want to post an executive session for the purposes of reviewing those meeting minutes, because you don't want to review those in open session, because as we'll get into a little bit further on here, any documents that are used during the course of an open session generally become public records, in which case they could potentially be subject to disclosure. Okay, minutes. Now, this is something Joe asked me to kind of focus on a little bit. So we have several slides that deal with meeting minutes, content, and some other best practice recommendations. So with respect to meeting minutes, they must include at a minimum the date, time, and location of the meeting, who was present, who was absent, and a summary of the discussion on each subject. The meeting minutes are not a transcript. They don't have to be a detailed transcript in terms of what everybody said during the course of the meeting, but they must include sufficient detail to allow a person who did not attend the meeting to reasonably understand what was discussed and how the board kind of came to its decision. All decisions made and actions taken, including a record of all roll call votes, must be included in the minutes. And a list of documents used at the meeting become part of the record. You don't necessarily need to staple them to the minutes because it would just overwhelm the town's filing capacity. But if a document is used at a meeting, and by that, that's used is defined as the document is physically present, verbally identified, and the content is discussed by members, it will be considered part of the record. If it's part of the record, it most likely is going to be a public record also. So you really need to be careful about discussing a document that would either be subject to an executive session or would be otherwise confidential in an open session, because just by quote unquote using it at the public session, it very well could render a document a public record when you didn't necessarily mean to do so. So some practical tips on putting together meeting minutes. We generally recommend, and most boards probably kind of do this already, that whoever is the person who's tasked with doing the meeting minutes, whether it's a member of the board or whether it's a staff person from the town that would be attending the board meeting, when you're going into the meeting, you may want to have a template kind of already set up that you're just filling in the blanks on. You can, copy and paste the agenda into that template and then just kind of fill in the discussion and the votes afterwards. It's oftentimes easier to, if you have somebody who's more capable typist than I am, to type the minutes as you're going, as opposed to taking them by hand. Most boards and committees tend to, particularly in the Zoom era, record their meetings, which often get posted to the town's website as well. So that can also be a pretty good source for purposes of assisting in the preparation of meeting minutes. But even if a meeting is recorded and posted, legally, a board is still required to take meeting minutes and approve those and file them ultimately with the town clerk's office. So meeting minutes, even if they're in a draft form, they're still considered public records. So even if the board has not approved them yet, if somebody makes a public records request for them, they would be subject to disclosure. If the meeting minutes have not been approved yet, you would want to obviously stamp them as draft until they're approved in final form. You should, if the board is, or the person who's keeping the minutes is using an audio or video recording for the purposes of assisting with the preparation, that recording can be destroyed once the minutes are approved. So you're not required to keep that unless there is a public records request pending for that particular item. If you anticipate that there's litigation that may arise, you may want to keep it, but you're not required to do so. Executive session minutes, you may withhold those until the purpose for which the executive session was called has been met. Otherwise, you're supposed to, on a periodic basis, review executive session meeting minutes to determine whether or not they can be approved for release. If you're going to do that, you would want to review those in executive session for purposes of determining whether they can be released, and if so, whether there's any redactions that would need to take place. You can, and again, so the purpose 7 is the specific purpose that would apply to going into executive session for the purposes of reviewing minutes. And that basically says that it's kind of a bit of a catch-all one that allows you to go into executive session for the purposes of complying with any law or granted aid. Minutes should be created in a timely manner. According to the Attorney General's office, they should be approved within the next three meetings or within 30 days, unless there's too good cause otherwise. Again, they become public records the moment of their creation, regardless of whether or not they've been approved. So some recent violations that the Attorney General's office has found with respect to meeting minutes. One was fairly recent decisions from 2019, 2020, with a failure to list documents that were used in the meeting minutes was found to be a violation. This one is, I think, one of the more obnoxious decisions I've ever seen from the Attorney General's office, but in a decision in 2019, the AG's office determined that a roll call vote that was required to be taken by roll call, it was listed in the meeting minutes as unanimous. And the Attorney General's office found that that was a violation because it didn't specifically identify each member and how they voted, even though the minutes say who was there and who wasn't there and indicate that the vote was unanimous. So details matter, I guess, is the bottom line. It's, again, something that keep in mind, that sometimes, even if it's not necessarily a substantive issue, the Attorney General's office will still find violations that have occurred when in situations like that, which is, in my view, a little bit too much form over substance.
Sorry, Tom, we got a couple of questions asking if the deck will be available.
Yes, yeah, we can put that up. I don't know, do you want to put it up on the website, or how do you want to handle that?
Yeah, I can do that.
Okay.
I can do that.
Or email it to committees. Yeah, yes, definitely. Again, these are some more kind of discussions, decisions where the Attorney General's office found violations with respect to meeting minutes. Again, it deals usually with the sufficiency and whether or not the discussion included enough detail so that people would be able to determine, who didn't attend the meeting would be able to read the meeting minutes and reasonably discern what was discussed and how the board came to the decision that it did. Okay, remote meetings. So since I thought it was appropriate to kind of address this issue, given that we've been operating in a remote world for roughly a little over a year now, and it's not really clear when we'll be back to probably a more predominant in-person meeting schedule. But it could, again, be some additional time before the governor determines that it's the state of emergency is over and it's safe to go back to in-person meetings. As I said, the capacity limitation was just recently increased, so it's now okay to have up to 100 people indoors, provided that you're able to properly distance and again, wear masks. Most, unless you're going to meet in a school auditorium or school gymnasium or some large meeting space like that, the likelihood is that most town halls don't have the ability to accommodate that many people. And I suspect that we'll still, for the most part, remain in a mostly virtual meeting world. The other thing to keep in mind too is that if you do decide to meet in person, it's certainly okay to do so as long as you stay within those gathering limitations. The problem that can arise is that if the limitation is 100 people, and person 101 walks up to the door, you can't shut the door and tell that person that they're not able to enter the meeting. What has to happen under those circumstances is that you need to stop essentially and adjourn the meeting and repost for another date and time. So something to keep in mind, particularly if if it's a normal meeting, I would expect that the 100 person capacity limit would not be a huge issue. But if it is a particularly controversial issue or something where there's significant public engagement, you may want to keep that in mind in determining whether or not you want to hold a in-person meeting. So under the governor's executive order, which was went into effect on March 12th of 2020, public bodies were relieved from several other requirements of the open meeting law, including that the meeting be held in a physical public location, as long as the public has adequate alternative means of access. And that's defined as telephone, internet, satellite-enabled audio or video conferencing, or other technology that enables the public to follow the proceedings in real time. You use Zoom. Most, I think, cities and towns that I know of use Zoom. There are a few that use other virtual platforms. So the notice for remote meetings must have clear instructions in terms of how to access the meeting. If it just said location virtual Zoom meeting without including instructions how to access that meeting, that would be a problem, and in fact has been determined to be a violation. So it should include the call-in number, passcode. Some towns, in order to eliminate or minimize the risk of a Zoom bombing event, will require the public to call in or email in to a particular town officer for the purposes of getting a passcode or other access information. And that's okay to do as long as somebody's available to provide that information at any time during the meeting. So if somebody isn't able to join when the meeting starts and they come in a half an hour into the meeting, somebody still has to be there from the town to provide them with the information they need to access the meeting. So generally speaking, we always recommend, if the meeting is going to be recorded, to make that announcement at the beginning of the meeting. I think most people are aware that these meetings are recorded, but it's just helpful for purposes of compliance with primarily the state wiretap statute. If a public meeting is recorded, it can be deleted after the meeting minutes are prepared unless there's a public records request pending for that video. The chair should announce the names of all board members who are participating remotely. And that's, again, even though your name might appear on the screen, people might not necessarily know, who is on the board if they're new to town or if they're not a town resident, but they're attending the meeting. So it's important for people to kind of know who the board members are. All votes, again, must be conducted by roll call during the any kind of virtual meeting. If you're having technical issues, it's best to suspend the discussion until such time as those issues have been resolved. If they can't be resolved, then we recommend that you reschedule the meeting for a different date and time. Board members should not be private chatting with each other or texting each other between, during the course of a meeting. That's, would be problematic and would be a discussion, obviously, outside of the course of a public posted open meeting, and could be viewed as a open meeting law violation under certain circumstances. If you're going to have an executive session in the remote world, the board members should just state that there's nobody else who's in their general area of their house where they're situated with their laptop or other device, and that other folks wouldn't be able to listen into that conversation. So at this point, I think most of us have done way too many of these Zoom type meetings, a lot more than we ever thought we would do. But if you're new to it, you definitely would want to do a practice run just to make sure you understand how the technology works, and make sure that you're comfortable with the platform. Someone should serve on the board, should generally, or a staff member who's going to be there should serve as the host. And on Zoom, for example, that gives the host has additional powers that attendees at a meeting would not have. Had the ability, for example, to put everybody on mute, and that sort of thing. So you want to encourage anybody who may attend a meeting to make sure they have the most recent updated version of the software downloaded. I had this issue come up recently in a town that's a representative town meeting, which if you're a representative town meeting, you can have a virtual meeting, and which was on Zoom, and Zoom had updated its software fairly recently, and a lot of people did not have the most recent software, which was problematic because they weren't able to. Took a while to get everybody admitted into the meeting, and because they weren't able to access it without the updated software version. Again, same of these, we've already kind of discussed some of those issues. So some of the more recent cases involving remote meetings where the Attorney General's office has found violations have occurred, where there was in one instance where essentially the cable recording was not live or in real time, which the AG's office said was essentially the same thing as being locked out of a meeting. And in that instance, it was not a Zoom platform that people were able to access. In order to, if you didn't provide, adequate access to the remote meeting, you have to show both an economic hardship and best efforts, which is virtually impossible, I think, given the low-cost options that are available, including, many free Zoom. I think up to a certain number of people you can have you can get for free. The other thing to keep in mind with the remote atmosphere is that the executive order that the governor signed only eliminated some of the requirements of the open meeting law, but not all. So you still have to record all votes by roll call. You still have to keep meeting minutes. You still have to post 48 hours in advance. You still have to include all the items that you're reasonably going to anticipate discussing on the agenda. So basically what the governor suspended is the physical requirement that the chair and a quorum of the board be present at a physical location for purposes of holding a meeting. Violations and enforcement. So as I said, the Attorney General's office oversees and enforces violations of the open meeting law. They have a specific division that handles open meeting law issues, which is called the Division of Open Government. If somebody wants to file an open meeting law complaint, they're required to file it in writing on the form that's been prepared by the Attorney General's office within 30 days of when the violation occurred, or when they reasonably could have known that the violation occurred. So, for example, if somebody finds out that a quorum of the board met at a cookout and they talked about this particular application that was coming before the board, That's not something that somebody would necessarily know about when it occurred. It might be something that you find out about sometime, later. And as opposed to if, for example, a board meets at a meeting and they go forward with the meeting and it wasn't properly posted 48 hours in advance, that's something that would be known, essentially at the time when the board met. That's the deadline, and that's fairly strictly interpreted by the Attorney General's office. Once the complaint is filed, it gets filed with the public body first, and then the public body has 14 business days to respond. And when you respond, you send your response along with a copy of the complaint to the Attorney General's office, and you identify any remedial action that was taken. In most instances, we typically will, if we're involved, we end up usually getting an extension from the Attorney General's office to respond, because what we'll typically do is we will prepare a written response, which takes a little bit of time to investigate, and then submit that to the board for review at a further meeting to confirm that what's in the letter that we prepared is accurate and reflects the board's position with respect to the alleged violation. And if we believe that there is a violation that took place, we would tell you that and would recommend some form of remedial action. The complainant, if they're dissatisfied with the board's response, can then file a request for further review with the Attorney General's office. That must occur within 30 days of when after it's filed with the public body, and within 90 days of when the violation took place, unless the individual is able to show some good cause why that didn't happen. One of the most common cures for a violation of the open meeting law is to post another meeting and engage with a properly posted agenda item to discuss that same issue that was discussed, perhaps at a meeting that was improperly held, and have a substantive discussion on that issue, and then vote to validate, ratify, or confirm your previous decision, or to take whatever action the board's going to take with respect to it. And as long as it's not a, just merely kind of a ceremonial act, and it's actual, legitimate discussion of that issue in a public setting, that will cure a violation. The Attorney General's office has a wide range of enforcement action. In most instances, they will just, typically give a slap on the wrist and say, you violated the law, be more careful going forward. They may say that you should attend a training session, such as something like this. They may compel you to disclose meeting minutes. They could nullify action taken by a board, although I don't think I've ever seen that take place. And they could impose a violation for a fine, of $1,000 for intentional violations. That does occur on occasion. It typically only happens if you have a board that continuously violates the law. They've been the subject of open meeting law complaints. The Attorney General's office has issued decisions, and they keep making the same mistake over and over again. Or there's some other factual basis to make a determination that the board just intentionally violated the law. The public body can seek judicial review of a decision within 21 days if they wish to do so. The Attorney General may file an action, obviously, as well, to compel compliance with the law, and 3 registered voters could also file suit in Superior Court. The public records law, it's really, would be another couple hours if we went into it in detail. But I think it's just important to note for any members of boards and committees, because they don't deal with the public records law as frequently as town staff would. But what's important to note for you as board members is that the public records law includes all records made or received by a governmental body, official, or employee, with some exceptions. So if you make or receive an email, for example, and you are, in most cases, it will be a public record if it relates to board business. That means that even if you are if you have a town email address, if it's, Jane or John Doe at, hamilton.gov, or if you're using, Jane or John Doe at gmail.com, if it involves public business that is the subject of your role as a board member, then regardless of whether you use your personal email account or a town email account that you've been provided, it will be a public record. And so just something to kind of keep in mind is that, anything that you make or receive in your role as a governmental body, or as a member of a governmental body or official, is likely to be considered a public record. There may be some exceptions in terms of whether or not it requires disclosure in response to a request, but for the most part, it will be a public record. And that includes emails, texts to some extent, notes, memoranda, photos, any recordings, social media posts. So just kind of something I think you want to keep in mind. And as I said earlier, if something is used in a public meeting, then it's very likely going to be a public record. And you also don't want to dispose of any documents without consulting with the proposal schedule. Texts are a little bit different, so I wouldn't kind of lump those necessarily in with the rest of other types of records, but again, just something to keep in mind. So I've included some additional resources. The Attorney General's Office website is actually quite good in terms of their open meeting law guidance. Our website at kplaw.com is also very good. We have quite a few different documents that are available for you to review, including probably one of our most popular handouts, which if we were in person, I would have had for you, is a summary and guidance in terms of how to go into executive session and the various purposes for going into executive session. So that's available on our website under, I think it's KP Law Knowledge Base. But if you certainly feel free to download or print out a copy of that. Many boards, and I often see various chairs of boards and committees kind of use that as a handy reference tool during the course of a meeting. So that's all I have for you tonight. If you have any questions, I'm happy to answer them now, or if you want to either email me or follow up by phone, feel free to do so. My email address is here, probably the best way to reach me, since we, like many of you, are still working remotely for the most part until things improve. So, but thank you for your time and attention, and look forward to seeing you all in person at some point.
So we do have one question from the audience in the chat. Were any of these OML violations in Hamilton?
No. No, those were all Attorney General's office decisions that we pulled from the AG's office website, and I don't believe any of them were Hamilton. Which is good. You have good legal advice, right? Okay, I think that's it. I don't know if anybody has anything else.
I had a bunch of questions, but most of them given the lateness of the hour, I'll pass on. But so on the social media issue, so if there are, so there's Hamilton Wenham community pages. Is the import of what I heard you say basically that, selectmen or other members of board shouldn't really comment on those because they might be seen by two or whatever other board members? Is that?
No, it's just something that's a bit of a risk that you're taking potentially. So I think if you are communicating directly with other board members through a social media site, that could be viewed as problematic. If you are commenting specifically on posts that other members of your board or committee has made, if you're receiving comments from other members of your other members of your board or committee, liking or commenting on things that you post on, that could be potentially problematic. So it's not necessarily that there will be a violation found under those circumstances, but it just raises the potential risk that the Attorney General's office will find a violation if the discussion is viewed as a serial communication between a quorum of the board. And so it's more of a caution as opposed to a outright prohibition. But, if one member of the board posts something, then, you probably don't want to necessarily comment directly on that member's post, particularly if it's a matter that is ultimately going to come before the board on an issue. So, for example, selectmen serve as the town's local licensing authority. There's a new application to have a tavern, restaurant, pub type of thing at a particular location. Maybe it's close to some residences. It's somewhat maybe of a controversial issue. One of the selectmen posts something on the site that says that it's a horrible idea. I'll never vote for this. Well, it's ultimately the person's entitled to a fair hearing, so it raises some due process rights. But if other members of the board start commenting on that, then you run the risk that essentially you're having what would be tantamount to a hearing outside the context of a public meeting, which would be problematic certainly from a due process standpoint under those circumstances, but also from an open meeting law standpoint.
Thanks.
Okay, thanks. Anybody else have a question, or everyone looking forward to having dinner right now?
Some basketball on.
That is true. Okay, well, thank you, everybody. Pat Shannon's here with me this evening, so he's going to make arrangements to have the slide deck available for people to refer to. And again, my contact information is on the last page. So if anybody has any questions, feel free to either probably email, but you can certainly call as well. So thank you all and have a
I think we
good
have to
night.
adjourn our meeting, so.
That's right. Yes, before we go.
I move to adjourn the selectmen.
Second,
All right, roll call vote. So Rosie,
Rosie Kennedy, aye.
Jamie.
Aye.
Is anybody else on from there? Selectmen?
No, you have to.
Bill
aye.
Olson, aye.
There you
Bill
go.
Olson, aye.
Well done.
Is
Anybody
there
else have to
somebody who
adjourn their
wants
meetings?
to volunteer from the from the Human Rights Commission as well?
I'll go ahead and move to adjourn. the Human Rights Commission meeting for the evening.
Okay, if we could just
Tina
get a roll
Holtz,
call of
aye.
members. Thank you.
Nancy Steffes, aye.
Christina Holtz, aye.
Oh, you beat me to it. Jamie Knutson, aye.
Elena Walsh, aye.
That's it.
All right, Jared, you have to vote.
And Jared Hughes, aye.
All right, Jared's the new chairman.
Ooh, no, we'll
Just a
talk
joke.
about that on Wednesday.
All right, well,
Tom,
thank you,
thank you very
everybody.
much. Appreciate
Okay.
your
Thank
time
you
tonight,
so much,
Thank you.
Tom.
Tom.
Okay,
Thank you.
thanks. Have a good
Thank
night.
you.
Okay.